Good morning, Mr. Carroll.
Good morning, Your Honors. May it please the Court, my name is Brett Carroll with the law firm of Holland & Knight. I am pleased to have the opportunity to appear before you today on behalf of the appellant, Hitachi High Technologies America, Inc., HTA or Hitachi, whichever you prefer. This appeal stems from the lower court's dismissal of HTA's claim for unjust enrichment based on lack of subject matter jurisdiction. Specifically, the appeal argues that the lower court erred in dismissing HTA's claim as a basis that it is preempted by ERISA. Applying the de novo standard, we ask this court to reverse the lower court's decision, finding that ERISA does not preempt the unjust enrichment claim.
Okay, Mr. Carroll, help me to understand better your position. I gather that you say that, according to at least the findings of the District Court of Massachusetts, you would have no remedy under ERISA for a faultless, for what occurred here, which is that the beneficiary was without fault in allowing the overpayment to occur, correct?
Well, Your Honor, we do cite to the SOCIA case as one of the arguments, but I think before we get to SOCIA, we have to first determine, does this matter, this unjust enrichment claim, relate to a pension benefit plan in the terms of that it would require preemption? That's the first key argument.
I understand that, but doesn't that, if we were to accept your argument, then you're basically asking us to provide a remedy in favor of or against a plan that the federal court under ERISA would say is not available under ERISA.
I don't think we are creating a remedy that the federal court is even addressing, because unless the matter relates to the pension benefit plan, ERISA does not apply. So I think it's important for the court to first look at that piece. If the court is in favor of finding that the plan does not relate to ERISA, and the courts throughout the jurisdiction, the country, federal courts have decided this issue, and I think the case, the Miera Court, the District of Massachusetts in 2005, set forth a good standard and summarized all of the circuit's positions on what relates to means to determine does ERISA preempt.
If Bowler had in fact said, no, this is not unjust enrichment, I was properly paid this amount, would you be precluded from coming to state court? I think
the facts of this case are very specific. The facts are not in dispute that there is an overpayment.
Yeah.
There is no question that we need to look at the pension benefit plan whatsoever. We don't need to look.
But what if there had been a dispute? Would ERISA preclude you from coming to state court?
Yes, Your Honor. I think that if there was a dispute over the amount of the pension benefit, for example, if Mr. Bowler stated that he was qualified for a certain amount based upon a certain number of years, and you had to look to the plan to determine that amount, to determine the time he was employed, to determine those issues, you have to look to the plan. And that's the point of ERISA, saying when you look to the plan, the federal courts are going to decide that, so we have consistency of the law.
But isn't there a dispute here? You say that you're entitled to interest. They say you're not. They say they're entitled to indemnification for the attorney's fees and the additional taxes they may be obligated to pay because of your overpayment. You say they're not. Isn't that not a dispute of fact which this court would have to resolve if we were to allow this case to be heard in the state court? I
think that there are disputes of fact that this court itself has decided in preemption matters where the court has found that preemption does not apply. I think that just because there's a dispute of fact, it does not involve the pension plan itself. There's no dispute in this case. The parties agree that there was an overpayment of benefits that was purely due to an actuarial error. There's not a dispute here that the pension denied certain benefits that were requested. There's not a dispute that under the terms of the benefit, the plan, that the beneficiary was entitled to certain amounts that he did not receive. Nothing needs to look to the terms of the plan. And when you don't need to look to the terms of the plan, the courts have said that the ERISA does not apply.
So just to follow up, though, if you lost on the merits, let's say it goes in state court and the state court says entitled to the beneficiary is entitled to interest and you, employer, have to pay all the taxes. Would that come out of the plan fund?
It would come out of the monies it wouldn't come out of the plan fund. It would come out of the monies that are no longer in the possession of the plan. They're in the possession of Mr. Bowler.
No, I'm saying he wins on the issues that Justice Gantz just asked. The court says, the state court says, he's entitled, or I guess it's you're not entitled to interest, and he's entitled to attorney's fees and taxes to be paid by you.
I understand. And so the question, I'm sorry, Your Honor.
The question is, so you owe money to him now. He has to pay back some, but you owe money to him.
I'm not, well, Your Honor, I don't think any basis has been pled for the award of attorney's fees in this case at all, so I'm not sure how the award of attorney's fees would come into play.
I guess I'm just trying to get to the question. If you have a dispute, and the dispute ends up, state court adjudicates, and it ends up that Hitachi owes money to Mr. Bowler, where does that money come from?
I don't see how Hitachi could owe money to Mr. Bowler in this case because he's been overpaid.
Okay,
but
they're saying here, listen, you gave me $170,000. You say that I should give you back $30,000. I've put it into, it was transferred to a retirement plan. Now I have to withdraw it prematurely from a retirement plan. There are tax consequences. I've got to pay for the fees of an accountant to help sort this out. You say you have to go back to IRS and get an exemption. He says, I'm sure that's going to cost me money to do all that. You haven't agreed to indemnify him for that. Who's going to pay? I mean, let's assume that the court says they're right. You can't basically say I overpaid and then not compensate him for the consequences of your error.
Well, I think in this case, unless I'm mistaken, I'm not sure first that there's a counterclaim for the fees or for the accounting fees or for whatever fees that might be incurred relative to this case. So I don't think that's before the court today. However, if the court were to find, if this court determines that preemption does not exist and the lower court had, or let's just say the lower court had determined that there was an overpayment and that unjust enrichment did occur, but that there should be a set-off for some certain amount, the court can do that. That does not involve the interpretation of the pension plan.
So the pension plan has no provisions whatsoever with respect to overpayment in it?
It has no provisions whatsoever. The lower court cited to a term in the pension plan that has no application whatsoever. It's about contribution to the plan. It's the monies the plan contributes. And if they contribute incorrectly to the plan, the employer contributes incorrectly, there's a way to get that money back pursuant to the plan. But this is a disbursement. It is a very different term of art. A disbursement, a payout to an employee, has nothing to do with a contribution. So the employment plan is silent on this issue. And therefore, I think that, because the courts have decided when no one seeks benefits under a plan, and there's no plan benefits that are denied, when the damages are not dependent upon an analysis of the plan, then you don't need to look to the ERISA plan and preemption doesn't occur.
So it doesn't matter that it's taking money. The money doesn't matter. It's whether you've got to interpret the plan or analyze the plan, the document itself.
I think this court has just looked at that in many other cases that it's been before the court in the last 15 years, where it has said, for example, and I may pronounce this incorrectly, Fernie versus Severin in 1996, that was a case where an employee stock ownership of trustees brought a breach of fiduciary duty claim. And this court said that even though it's a breach of fiduciary duty claim that included claims of defamation, because they looked to the plan to look to the terms of what you had to do as a fiduciary, the fiduciary terms were defined by that plan, it's preempted. You look to the plan itself. And
Mr. Carroll, forgive me, and you may have answered this question, I just didn't get it. Here there appears to be, as I understand it, no dispute that there was an overpayment.
You're correct,
Okay.
Your Honor.
And so that whatever the negative consequences of the overpayment to you, your client, is out approximately $30,000, I think, and to the recipient, because the recipient will incur damages if the recipient has to pay back. What if there were a dispute?
Yes, Your Honor. I think that if there was a dispute over the amount that was owed, if there was a dispute over the amount was owed, for example, if Mr. Bowler stated that he had sent in his request for disbursement of his retirement fund after he had retired from Hitachi and said, I want my monies, and Hitachi said, you're not entitled to them. He could that would be an entitlement claim.
I'm just taking in this case. He says, I don't agree with your calculation. I'm in fact entitled to the full $30,000.
And I think there would be that in that situation, he would arguably be looking to the pension benefit plan, the determination of how benefits are calculated, and that's what this court or any other court would need to do. You would need to look at the pension benefit plan to determine what are the amounts due. And in that case, I think Hitachi or any other person would be hard-pressed to say that the claim should not be decided by looking at the terms of the plan. Now, I do think that it's important for this court to note, and the lower court pointed it out, that if the court were to look at this case and say, okay, for some reason we deem that the pension benefit plan is involved, in SOCIA, the District Court of Massachusetts has stated that in that analysis, when you're looking at a recoupment of monies under a pension benefit plan, the way that the plan needs to go about that, the only way they can recover under ERISA is if there's fault due on the part of the beneficiary of the plan, in this case, Mr. Bowler. So if the court is to look at this case and says that the pension plan is implicated, they need to, that fault needs to be in the place of Mr. Bowler. Otherwise, there's no recovery.
Mr. Carroll, I'm sorry, let me just ask you a question that I've previously asked in a different way. If Mr. Bowler is entitled to some kind of a set-off, is it your view that that set-off, whether it be either equitable or legal, is entirely a matter of Massachusetts law?
I'm sorry, if he is entitled to a set-off from the amount for the taxes he may incur, that he may have incurred.
Do you agree that that is entirely a matter of Massachusetts law?
I do agree that that would be a matter of Massachusetts law. I think that the court, a state court, sitting in Massachusetts can look at an unjust enrichment claim and determine, in this case, the only fact is the only decision that needed to be made is it unjust for Mr. Bowler to retain the benefit? If it is unjust, should there be some kind of set-off for anything he has incurred? And the court can apply the principles here because he's incurred the tax implications here in Massachusetts, and if he incurred taxes here, the court can interpret that law here.
Now, if there were some claim of fault on the part of Mr. Bowler, would you say that's purely a state law claim?
If there's a claim of, if Mr. Bowler, for example, if in this case the facts are that he defrauded Hitachi,
right.
And no, I don't think that that's a state law claim because I think that based upon the SOCIA decision and other decisions, for example, Owens and the Supreme Court decision of Mertens, he would have received those benefits as ill-gotten gains by fraud.
He would have received pension benefits by ill-gotten gains.
Yes, Your Honor.
And you would have to look at the pension plan to determine whether or not they were ill-gotten.
Yes, Your Honor. I think that that's what the courts are saying. In circumstances of fraud, the courts seem to be particularly concerned about the fact that a fraud has been committed upon the pension plan. And in those circumstances, the courts seem to want consistent decisions in determining that in this circumstance, we're going to look to the plan, was a fraud committed, and interpret and have consistent case law. In this case, I don't think that if the lower court makes a decision, unjust enrichment in this circumstance or not, is going to have any bearing whatsoever on the facts of another case because it's so fact determinative here that there's no disputes whatsoever.
Are there any consequences to Mr. Bowler under the pension plan for resisting, as he is, I'm going to use that word for lack of a better word, for resisting to return the money that was erroneously paid to him?
No, the record there's nothing in the record to that effect, and there's nothing in the pension plan to that effect. This is purely...
I thought the money's all been taken out and rolled over, right? It's not in the pension plan anymore.
No. I'm sorry if I misspoke. Yes, the money is taken out, and it is in his own personal IRA under the control. We believe that's as far as what we know as of the record previously.
So I'm sorry.
Mr. Carroll, other than wanting to have a federal judge, which we perfectly understand, what are the consequences if this gets decided in state court rather than under ERISA in federal court? I mean, what are the practical consequences?
If this gets decided in state court versus, is there a reason that it needs to be decided in state court?
No. What difference does it make? I mean, we have jurisdiction over federal claims. We decide federal issues all the time. I know we don't do that under ERISA. What, as a practical matter, does it affect remedies? Does it affect... What's the difference?
I think that that claims in the ERISA should not be all-encompassing. There are limits to ERISA.
No, I understand that, but
is there a
it's
difference?
A practical matter. If this were a diversity case, you could pop it over to the federal court, right?
Yes,
So,
there
so
is a
what's your,
difference.
as a practical matter, what's your interest in having it
If we
decided?
were forced, if this court determined that the lack of subject matter jurisdiction was true, that this was preempted, we would needed to have gone to federal court. And in federal court, we would have had to have filed a claim for equitable relief enforcing a term of the plan or enforcing a term of the statute. Well, there's nothing, we're not enforcing anything under the statute. And a clear reading of the plan, we're not enforcing anything under the plan. There's no term of the plan that we're enforcing. So on that basis alone, we could be booted out of the federal court and have no remedy whatsoever.
Okay, so your position, the reason you're here is because you don't have a remedy in federal court.
I don't think that that's necessarily the total reason. I think that the courts here can decide because this is not preempted. I think that's the main point.
But the risk you run, in answer to the Chief Justice, is that you may have, if we say we don't have jurisdiction, you may get the same answer from the federal court and then you're nowhere.
I do, and based upon SOCIA, I think that's the result. And in this case, the amount is $29,000. But what if a computer, and we have errors all the time and we've received them, adds 10 zeros at the end, and we're talking about $10 million, and there's no recovery? It just doesn't seem fair. Thank you, Your
Thank you,
Honors.
Mr. Carroll. Good morning, Counsel. Is it Mr. Lowlands? Mr. Lowlands?
Lawrence.
Lawrence.
Just spelled a little bit funny.
Okay. Good morning, Mr. Lawrence.
Good morning, Your Honors. Gregory Lawrence for the appellee, Kevin Bowler. If I could, I wanted to clarify one matter, and that was that the damages that Mr. Bowler incurred were the tax liabilities, were as a result of the receipt of the payment, not necessarily taking it
Well,
out of the IRA.
you may have both. I understand, but you may have both.
Right. So the second that those funds were rolled over and it wasn't a qualified distribution, it was income to him,
Okay.
and he had incurred those damages. So
He's already paid taxes, but he may have further tax
right, there's
consequences.
excise taxes, federal income tax, state income tax, and he can't recoup those benefits because he's not in the same tax bracket. However, with respect to the
Don't you agree that there's a remedy here? It's an overpayment. Happens all the time in commerce. And don't you agree that there's a remedy here?
there's not a state law remedy, I would contend, because the matter
So
is
you say
preempted.
there's absolutely a federal law remedy. If they just filed this in federal court, the money would go back and wouldn't be a problem.
Yes, if they could meet the elements of the federal claim, there would be a remedy. And
What are the elements of a federal claim?
The real distinguishing difference is that a claim in state court for unjust enrichment, they'd be imposing liability against Bowler personally and generally, you know, whether he took the money from his house or seized his car. In federal court, they have to be able to trace it to a particularly identifiable fund. So, for example, the actual funds that were in the IRA.
As a matter of ERISA law?
Yeah, Section 50283 allows the plan to sue for other equitable relief. And if you read, it's the it's the Knudsen case and the Sereboff case, the U.S. Supreme Court deals with what is equitable relief. And the requirement there is that you be able to either have a constructive trust or an equitable lien on specifically identifiable funds. You cannot impose liability against Bowler or any other ERISA defendant under that section generally. So that's one distinguishing feature.
So that's the benefit to your client of being in federal court.
That is one benefit. And there's also the issue of wrongdoing, which oddly enough, Hitachi's of the position that they would need to show wrongdoing under an ERISA claim. And I'm representing Bowler, and I contend that they would not need to show wrongdoing. I believe that is erroneous. And
You don't agree with SOCIA. You don't agree with their leading of SOCIA, or you don't agree with SOCIA. I haven't led SOCIA.
my understanding of both SOCIA and the Owens cases, the cases there's a line out of the Ninth Circuit,
Yep.
is what occurred was the Ninth Circuit and some of the other circuits had a split on what was allowed under 50283. And the Ninth Circuit particularly read the equitable relief very, very narrowly. And so what happened was they essentially needed to carve out an exception of their narrow ruling, because you could have situations where someone literally commits fraud, as my brother proposed, with, you know, add 10 zeros to the end of it, and there'd be no remedy under ERISA. So I think that was a carve-out that's essentially incorrect, and that the U.S. Supreme Court in, I believe it's pronounced Sereboff, in 2006, remedied that issue, where they addressed specifically, okay, what is the requirement for a plaintiff to be claiming equitable relief? And that's the constructive trust theory or the equitable lien. It's that they're seeking to recover specifically identifiable funds, not impose liability generally. So on that basis, and I cite a number of cases in my brief out of various circuits where they've made specific findings at the circuit level that no showing of wrongdoing is required. It just has to be a claim to recoup a specifically identifiable fund. So that's my contention that that is incorrect. The heart, I believe, of the disagreement and where it gets somewhat confusing is that the courts analyze preemption under basically two different rubrics, and one is Section 514, and that's the relates to language. And as Hitachi aptly noted in their brief, that gets frustrating because depending on how you construe it, everything could be preempted or very little. So what the court ultimately ended up doing was identifying three areas where they say, these are areas that are at the core of the ERISA concerns, and these are going to be preempted. And this is where I direct the majority of my brief, and that's alternate enforcement mechanisms. This case is clearly an alternate enforcement mechanism. They're seeking to, an ERISA-governed plan is seeking to recoup an overpaid benefit to an ERISA plan participant. And what the issue is my contention is that they don't like the remedies that are available to them in federal court or the burden of proof. So they're attempting to do an end run around the ERISA statute by artful pleading. The promise of preemption would be completely hollow if, if the remedies are there, great, you file an ERISA claim, and if the remedies aren't there, you bring your garden variety state law claim. There'd be no preemption essentially whatsoever. It'd be a hollow promise.
Well, the question is whether the federal statute intended to preempt a remedy such as this.
My contention is that it would be. When you review the case law, they come right out and say that ERISA is to be construed broadly, and that contains one of the most powerful preemption provisions in all of federal statutes, such that it even abrogates the well-pleaded complaint rule. There's a line of cases, it's Aetna versus Davila, which deals with complete preemption, such that if you bring a state law claim, a defendant normally wouldn't be able to just remove that to federal court. But what the U.S. Supreme Court has said is that ERISA preempts so powerfully that it will take a state law claim, essentially by magic, convert it into a federal claim such that you can remove it right to federal court. And so it is to be construed broadly.
Can I ask you a question? You said there was a 2006 U.S. Supreme Court case.
Yes, I believe it's...
Because I don't see it in your brief, but I may have missed it. Did you?
It may not be cited in my brief. It is Saraboff versus Mid-Atlantic, and it's 547 U.S. 356. And what that case did was clarify the nature of what is equitable relief under this subsection of the code.
The 502A3?
Yes, under Section 502A3. And that's one other complicating factor in looking at the ERISA preemption cases, is that a plan participant or beneficiary, Congress saw fit to provide concurrent jurisdiction between the state and the federal courts. So if this were the converse situation where Bowler were suing for an erroneous overpayment,
Could be here.
it could be in the state court.
Sure.
But when it's backwards and the plan is suing to recoup its erroneous overpayment, that has to be brought in federal court. So that's one area where the majority of the cases that you'll see on preemption are the plan
participant is being
Yeah,
harmed.
Bowler is suing in state court. He's brought a state court claim, and the defendant is usually a bigger corporation. They don't want to be there. So what they do is use the complete preemption doctrine to say, nope, this is governed by ERISA, and then remove to federal court. So the procedural mechanics of the cases vary. And then my last point would be that under the plain relates to language. What Congress is driving at and what the courts say is Congress was looking to regulate I think they call it the intricate web of relationships between the ERISA actors. They weren't looking to just cases where there's plan interpretation. And in this case, in its most common sense, you've got all the ERISA actors. You've got the ERISA plan suing the ERISA beneficiary. to recoup an erroneous overpayment. And even the facts bear that out. If you look at, I believe it's 2 of the 3 Hitachi demand letters, they say, one's from the benefits administrator, Mr. Bowler, you're going to have to pay this back, or we're going to have to sue you in federal court under ERISA, because of our fiduciary obligations. There's another letter from their general counsel who says the same thing. Mr. Bowler, you're going to have to pay this back, or we're going to have to sue you under ERISA. And then
And that makes sense, right? I mean, they have fiduciary relationships, and if they just overpay, if they overpaid accidentally by $20 million, maybe the plan would be in jeopardy.
Absolutely. But the core point to that is that the fiduciary duties are obligations that are imposed by ERISA. And,
I understand that.
and so what I'm driving at is that this very case implicates the complex web of relationships. And that's what ERISA was designed to regulate and to have uniformity. And
But they're not really, they're not suing you on a theory that they have a duty to sue you. They're suing you on a duty, or on the basis that your client was overpaid, and they have an equitable right to recover that money.
Well, that's
That
because
is
because
partially
they've
correct.
stated. I mean, the answer to that may be yes, but that's because they've stated it that way.
yes,
So if you
yes
had
and no.
if you had plan fiduciaries, and it turned out that every time they paid out a departing employee, they double paid or triple paid, they probably would have a duty. Right?
If they did not sue you, if they decided not to sue you, could any of the other beneficiaries under the plan sue in the name of the plan?
Yeah, it's my understanding that the plan beneficiaries could then bring a case against the fiduciaries for allowing plan assets to be dissipated. And going back to their stated purpose, I do believe those 2 letters are in the record and were in evidence. And also
We will have to sue you.
under ERISA and in federal court. And among other things is Hitachi's trial counsel, even in their closing argument, comes right out and says, hey, this case isn't about the money. We've got these fiduciary obligations to file suit. And that's clearly the ERISA web of relationships.
Can I go back to the Ninth Circuit case? That's FMC Medical Plan versus Owens.
Yep.
1997. Does this new Supreme Court case basically overrule Owens or suggest that Owens got it wrong when it said that certain kinds of equitable relief couldn't be pursued under the ERISA plan? Would have to be pursued elsewhere?
It does not expressly overrule Owens. My understanding is that the Ninth Circuit ended up with a cramped construction of what was available equitable relief.
I mean, in Owens, you have the plan suing a member of the plan.
Correct.
For reimbursement of money.
Right.
And the court said they couldn't get it in that under ERISA. They'd have to get it some other way.
Correct. And then because the Ninth Circuit had a requirement of wrongdoing, and if you couldn't show wrongdoing, you couldn't recoup. But I believe that requirement was erroneous, and there was a circuit split on that. And the court in the 2006 Sereboff case really came out and clarified, okay, what are the requirements under Section 502A3? What is the equitable relief? And the driving nature is that you're looking for a constructive trust or an equitable lien to particularly identified funds. I don't think you'll find any language in that case that suggests that they have been ill-gotten or that there have been some fraud. And
Are you familiar with the Ninth Circuit case in McDowell?
I'm not off the top of my head, Your Honor. I
No, I'm
apologize.
just looking at, because again, it was a claim for, it appears to be a, claim for repayment, and as far as I understand it, the Ninth Circuit says, no matter which way you do it, it's simply attempting to enforce a contractual obligation for repayment. This is a classic action at law, not an equitable remedy.
Okay, that is the very nature of the question that the Supreme Court deals with in the Sereboff case. They come out and there's a line in there where they say, we're not looking at the particular label that you affix on the claim, that it's contract
Equitable.
or unjust enrichment.
Yeah.
What we're looking at, what the driving factor here is what is the remedy that you're seeking?
And what year is that? The Serboff case?
2006?
Okay, so it's after this one.
Yeah, and so that case really clears that up. As I said, there was a very significant circuit split on what was proper equitable relief and whether there needed to be a requirement of wrongdoing. The Sereboff case does not make any mention of there having to have been wrongdoing. The driving factor is what's the equitable relief you're looking for. And then finally, as a matter of unjust enrichment, even under the state standards, really this is a case where Mr. Bowler, from the erroneous overpayment, was impoverished. He's incurred significant federal, state, excise tax liabilities, accounting liabilities, legal liabilities, all over $30,000 that he offered to return, provided that Hitachi indemnify him against tax liabilities that they contend simply don't exist. So it seems a little incongruous to me, or disingenuous, that they can suggest that Bowler is supposed to rely on, I believe they say, the IRS's grace in remedying this situation, when they won't indemnify him against these liabilities as a result of their mistake for funds that he offered to turn, just to give back to them. And I'd suggest that even if this court does not find preemption, that the trial court was correct that an unjust enrichment claim would not lie. Thank you.
Thank you, Mr. Lawrence. We'll take a short break.